Hey, all right, so real quick. So, when you guys answer questions like either on the YouTube or on here from other officers, and you reference cases from other circuits, but the case technically is not in that respective officer's circuit, does it
Correct. Yep.
still apply, or is it more of like an legal advice of like, hey, just letting you know this circuit said this, your circuit might say the same thing if it comes to that point?
Man,
That's
I
just like,
first of all, I love this question. It is such a great question because I'm sure that a lot of people actually have that question. John's going to answer it for you. But money question. What do you think, John?
All right. So, Emmanuel, basically what we've got is we've got mandatory and persuasive authority. Okay. So if you say, let's say hypothetically, you're working in Texas, right? Texas law controls what you can do, as does the Fifth Circuit, as does the United States Supreme Court, right? So that is your hierarchy of mandatory authority. Then we have persuasive authority, which is from other states or from other circuits, depending. Okay. Basically, what that means is your hierarchy above you is not bound by those decisions necessarily from the lower courts, but they can use their rationale to reach the same conclusion or reach a different one. So it's mandatory versus persuasive authority. A lot of times when we have kind of unique issues, they may not be identified in other circuit court cases.
Right.
What we try to do when we teach in a specific state, right? Like, so I'm teaching in Arizona right now. And so I'm teaching as much Arizona specific case law as possible, as much Ninth Circuit case law as possible, and then as much United States Supreme Court case law as possible. But there are certain points that we're making that maybe there isn't a Ninth Circuit case directly on point. And so we say, well, I've got one out of the 10th Circuit. I've got one out of the 11th Circuit. I've got one out of the 4th, 7th, whatever it is. Just understand this is that court's rationale. It's persuasive authority, not mandatory authority for you, but it gives you some direction.
Okay, I want to add something to that. So here's the other thing, Emmanuel, is that blue to gold, we're the experts in search and seizure. This is what we do. This is our passion. This is John and I. We don't really go outside our sandbox when it comes to search and seizure. And the reason I bring that up is because I have plenty of cases. Like I have a case out of the First Circuit called French versus Morel, and it's a phenomenal case. And I know that it's a case involving a knock and talk gone bad. But the reason I bring up that case is because I'll teach that case. You're in the Fourth Circuit, Emmanuel, because you're in Maryland, right?
yes, that's right.
And so I'll teach that case when I go to Maryland. And the reason I teach is that, hey, this is not binding. You can ignore it if you want, but you're taking a huge risk because blue to gold, our expertise is search and seizure. So we get paid to predict what your courts are going to do. And so what I say, look, if you have this same situation that occurs in your district tomorrow, I'm going to tell you that probably, your courts, at least at the appellate level, right? Because, trial courts are kind of, some judges don't get it right. That's why we have appellate courts. But at the appellate level, hey, I'm telling you, like, they're probably going to look at a case like Morel, and they're going to say they got it right. And so because my cop in Maryland did the exact same thing last night, that's the outcome right here, which wasn't not a good outcome for the officers. And so I just want you to know that when you come to when you and all your friends, they come to Blue to Gold, they watch YouTube channel. Yes, we are talking about general law. We're talking about best practices, but we have always said around here that our advice, we feel very confident. Now, this is just training. This is not legal advice, but our training is we feel confident it's going to win at the U.S. Supreme Court. It's going to win at the circuit courts. And that's why you come here. Now, you work in a state that relatively is a Fourth Amendment state. Maryland, surprisingly, how liberal they are, has not turned into constitutionally has not turned into a New Mexico, New Jersey, or Washington. Even though I'm surprised that they haven't. But when we teach, like John teaches a lot in Washington, when he goes to Washington, man, his whole game changes. It's very restricted there, and we have to know our game plan. But I got to tell you, that's why you notice that I ask cops like where they're from, what state. And the reason why we're doing that is because I want to know, okay, I can tell them that most likely this is what their courts are going to be looking for. Does that make sense?
Yes, absolutely.
Yeah, that's a great question. All right.